Okay, guys. In Malaysia, the provisions concerning government privilege can be gathered from the various sections in Evidence Act 1950. So this is the statute the applicable for the government's privilege. And then we also must look into the decisions of cases. Okay. Okay, the first provision is under section 123 of the Evidence Act 1950 state that all unpublished official records that relate to state affairs cannot be revealed. However, the discretion is on the head of department to determine whether certain information is necessary to be revealed or not. Okay. So as for explanations of this provision, section 123, okay, basically, no one is allowed to disclose any unpublished official record. Okay, however, there is an exception whereby, okay, the power to decide whether it can be revealed or not is given to the head of department. So later, head of department will decide whether such information, whether such documents can be revealed or not. Alright, so this is the first point in section 123. Okay, next provision under section 124, even the discretion is given to the public officer to reveal any information or not, the decision is still up to the head of department. Okay, section 124 says that public officer may reveal the information. Okay, they have a discretion to reveal the information. However, it still depends on the head of departments. Okay, so head of department will decide whether this public officer may reveal the document or information or not. If the letter certifies, letter here referring to the head of department. If the letter certifies that the disclosure will not jeopardize the public interest, then the information will be released. So what we can say from this provision is that, yes, public officer has discretions to reveal or not the information. However, the decision is still given to the head of department to decide. And normally, head of department will decide or will give the permission to disclose such documents if it is not jeopardized to public interest. Okay, and the third provisions of under Evidence Act 1950 is section 162, subsection 2. If the document is related to state affairs and the court will not be allowed to examine such documents. So court has no power to examine if it is related to state affairs. However, okay, there is an exception. This does not mean that the court will unable to examine it at all. The court may call the relevant officer to give evidence in order to determine the validity of government's privilege. Okay, so when the court wants to examine the documents, then court may call the relevant officer. Okay, and then the relevant officer has to testify the information. Okay, he must give evidence in order to determine the validity of government's privilege. Alright, basically, sections 123, 124, and section 162, subsection 2 indicates that certain official records which are not published that relate to the state affairs or any other documents that if revealed will threaten public interest shall not be produced as evidence in the courts of law. Okay, so even we want to use the evidence, the information as the evidence in court. We want to use the unpublished record in court, but we cannot do so. Okay, otherwise the head of the department give permissions. Okay, so if the head of the department give consent, and then yes, we can use that information as evidence in the courts of law. So generally, these are the conclusions of the three provisions under Evidence Act 1950. So the governments possess a special privilege over this information. Okay, special privilege not to disclose the information. However, it is not the executive, but the court will decide whether the document will be revealed or not. Okay, at the end, they concluded that, okay, the power is not given to the executive, but the court will decide whether the documents will be revealed or not. Okay, so we also follow the decisions in Conway's case. Okay, the principle in Conway's case. Court will decide, not the executive. Okay, example of case. We refer to the case of BA Road against Sapuran Kaur, 1978. In this case, the respondent claimed compensations on the death of the deceased for the negligence caused by a medical officer in a district hospital. So in order to claim for compensation because of negligence, there must be an investigation first. So an investigation committee was set up for that purpose. The respondent later requested for the result of the investigation to be revealed in the court. So the respondent wants to know the results. And the appellant had refused to grant permissions on the grounds that the report of such an investigation was an unpublished official record and gained special privilege not to be revealed. But the hospital claimed that, okay, the reports here constitute as unpublished official, and therefore the hospital has a special privilege not to reveal such a report. Okay, and then the court decided that, okay, whether the disclosure was necessary or not according to section 124 or 162, the court will have to do so, not the executive. When the government or a doctor was claimed because of their negligence, they couldn't protect the unlawful conduct from the knowledge of the court. So in this case, okay, they leave to the court to decide whether the respondent can have access to the documents or not, to the reports or not. Okay, so we give the power to court. And in the case of Joh Kong Ju against Medical Authority of Hospital Sultanah Aminah JB, 1990, the court held that the report was important to be revealed because of public interest. Okay, so the same facts happen. Okay, so at the end, court will decide. Court will examine first and then will decide whether such documents may be revealed or not. Okay, next we continue with government secret official.